So welcome everybody to this webinar and campaign launch, more or less. Stand with Colombia inside the global fight against corporate courts. Many of you will be familiar with corporate courts already because Global Justice Now has been campaigning on corporate courts really for a decade, actually, since we first worked on it, campaigning against the Transatlantic Trade and Investment Partnership. But more recently, just about a year ago, we had a really fantastic campaign victory in our campaign against the Energy Charter Treaty, which is a big, essentially a big corporate courts treaty for the energy sector, which we managed to convince the government to leave because it threatened their commitments under the Paris Climate Agreement. A similar rationale was put forward when other European countries left the Energy Charter Treaty. And really that was it was a fantastic step forward. Already around the world, some countries had started to question the usefulness of corporate courts as they were more and more sued by companies for various reasons, but particularly by mining companies, oil and gas companies. And Colombia has been really on the front line of this attack by corporations using this ISDS system, the investor state dispute settlement system, what we call corporate courts, not just because it rolls off the tongue a bit more easily, but because they really are courts that are just for corporations. So in many ways, it seemed like an obvious next step for us to work specifically on the treaty between the UK and Colombia, which also allows these corporate courts to happen, as do many of these kind of bilateral treaties. But Colombia, the one between the UK and Colombia has now reached its initial 10-year period. Renegotiation is possible. The Colombian government has said that it wants a change. So that's what we're going to try and do. And my colleague Cleodie is going to explain more about the campaign towards the end of this webinar. But before we do that, we'll be hearing from some other fantastic speakers. Guillaume Long, who is the former foreign minister of Ecuador, who actually led his own country through the process of terminating investment treaties, just like this. Also from Sebastián Abad Jara, who is a lawyer, researcher with the Ecosystems Program of the Interamerican Association for Environmental Defense. He's based in Latin America. He researches issues including the decolonization of law, the rights of nature and indigenous peoples, and business and human rights. And he's currently working on the ISDS cases concerning Colombia's mountain wetland ecosystems. So we'll have Sebastián first, and then followed straight on by Juan Tavera, who, as I said before, is from the Committee for the Defense of Water and the Wetlands of Santurbán, the Paramo, as they're called, in Colombia, which have been threatened by metal mining by multinational companies, and the committee that he's part of is a social movement which is made up of 40 civil society organizations representing around 75,000 people, and it was founded in 2010. So we'll hear from Guillaume and Cleodie later on, but let's start with Sebastián and then Juan. So Sebastián.
Thank you very much, James. I'm going to share my screen. Just give me a second. Can everybody see it? Is it possible to see it? Perfect.
Sí, perfecto. Sí.
So good afternoon, good evening, depending on where you're watching this event. On behalf of AIDA, thank you very much to Global Justice Now for the invitation. AIDA is a Latin American organization that for more than 20 years has been working in the region for the protection of the environment and the rights of communities through science and law. Me, along with Juan Tavera from the Committee for the Defense of Water and the Santurbán Páramo, will assess how Investor States Dispute Settlement, ISDS, has influenced efforts to protect Colombia's páramos, particularly in the Santurbán's region. The objective is to highlight how such arbitrations can constrain environmental regulation and to explore 4 key criticisms raised by experts and international bodies, such as the UN Special Rapporteur on the Human Right to a Healthy Environment, or the UN Commission on International Trade Law and the UN Trade and Development. So this presentation will be divided in 2 parts. The first part will be delivered by me, and we'll explain briefly what ISDS is, briefly set out the significance of the páramos, then offer a concise background of the Ecuador case, and then explore the 4 main criticisms of the ISDS system in the light of the Ecuador award. The second part will be presented by Juan Tavera, who will address firsthand the impacts of metallic mining in Santurbán and how ISDS disputes have influenced local efforts to protect this fragile ecosystem. So what is ISDS? It's the mechanisms included in many international investment agreements, including bilateral investment treaties and free trade agreements. It's a system in which foreign investors can bypass domestic courts and take disputes straight to international arbitration, usually under ICSID or UNCITRAL rules. It is important to highlight that ISDS tribunals have been conceived on whether government measures have breached treaty obligations to protect investors, and not on obligations investors might owe to communities or the environment. And having already known what is the ISDS, why are the páramos important, and why is it important to protect them? And Colombia's páramos are high mountain wetland ecosystems that play a central role in water regulation, biodiversity maintenance, and climate change mitigation. Specifically, páramos store and release water, providing drinking water to millions of people in both rural areas and major cities like Bucaramanga. They also harbor numerous endemic plants and animal species, many of which are particularly susceptible to habitat destruction from activities such as open pit mining. In addition to that, páramos also soil function as carbon sinks, capturing significant amount of CO2. So disturbing these soils can release stored carbon and accelerate climate change. So having set that frame, let's have a brief overview of the Ecuador case. And although in Colombia there are 3 key disputes, Ecuador versus Colombia, Red Eagle versus Colombia, and Montauk, former Galway Gold versus Colombia, Ecuador best exemplifies the tensions between environmental regulations and investment protection. So my presentation is going to be focused on how this award portrays and evidence the criticisms that the ISDS system has. So Ecuador Mineral Corp is a Canadian company that obtained a mining permit for the Angostura gold and silver deposit in 1994. Ecuador, in its petition, in its arbitration petition, argued that Colombia's evolving legal framework, which prohibit mining activities in páramos ecosystem, rendered its mining concessions unworkable. Having initially planned an open pit project, Ecuador found itself subject to changing regulations, new environmental boundaries, and stricter licensing requirements. The company ultimately claimed that these measures amounted to an indirect expropriation of its investment, as well as a breach of the minimum standard of treatment under the FTA between Canada and Colombia. The tribunal acknowledged certain acquired rights of Ecuador. However, it also recognized that the measures restricting mining in the páramos, specifically the páramo de Santurbán, were legitimate steps to protect this vital ecosystem. Despite this, the tribunal found that the inconsistent and ultimately delimitation of the páramo have undermined Ecuador's reasonable expectations, thereby breaching the minimum standard of treatment under the FTA. So, based upon this case, after carefully reviewing several sources on the matter, such as the specialized literature and major international institutional reports, as I was saying, and based on a field visit in which AIDA could participate in 2023, we can identify 4 key criticisms that emerge clearly in Ecuador. The first one is the predominant focus on investor protection. ISDS treaties generally lack provisions requiring investors to respect human rights or avoid environmental harm. In this regard, the UNCITRAL Working Group 3 reports, like the one published in 2019, can help us understand how this system creates an asymmetric framework, since it has emphasized, the working group has emphasized, that most investment treaties lack investor obligations regarding the environment or human rights. The IPCC in 2022 has also highlighted that many bilateral and multilateral agreements include provisions designed solely for the protection of the interests of the investors. In Ecuador, this is not the exception. Actually, it's an example of this, because Colombia's measures to safeguard the Santurbán páramo, which could be justified under Article 2201 of the FTA, that prescribes that nothing in the FTA investment chapter, and I quote, shall be construed to prevent a party from adopting or enforcing measures necessary to protect the environment. For the arbitration tribunal, that article was not enough. So the arbitration tribunal decided to prioritize Ecuador's interest over environmental obligation of Colombia state to protect the páramos. Even though this article is modeled after a similar general exception provision in that is prescribed in Article 20 of the General Agreement on Tariffs and Trades, and similar provisions that can be found in many investment and trade treaties worldwide, the tribunal waived away this exception, deciding that if the exception applies to a measure, and I quote, this does not prevent an investor claiming that such measure entitles it to the payment of compensation. This reasoning was criticized even by one of the arbitrators, who in his dissenting opinion affirmed that the approach taken by the majority of the arbitration tribunal failed to respect the text agreed by the drafters of the FTA, and is likely to undermine, and this is important, it's likely to undermine the protection of the environment. Even in this dissenting opinion, the arbitrator recognized this. This was also emphasized by UNCTAD, who has criticized this position by affirming that the Ecuador decision sheds doubts of the effectiveness of countries' efforts to rebalance investment agreements by including explicit safeguards and exemptions to protect the state's rights to regulate for the protection of the environment. The second criticism is the absence of effective community participation and power asymmetries. Because of how the system is designed, communities are excluded completely of any decision-making, from the treaty negotiation passing by the negotiation of the concession contracts, and even worse during arbitrations. And this is because people most directly harmed by environmental degradation, such as indigenous communities, farmers, local residents, lack a standing to sue foreign investors and the ICSD. The special rapporteur for the right to a healthy environment has affirmed that foreign investors enjoy preferential access to justice because they can bring ISDS claims against governments, but neither governments nor affected communities or individuals can bring these claims against foreign investors. Right holders, communities who are being affected by these projects, are relegated to possibly participating in the best case scenario through an amicus. But this is at the discretion of the tribunal without any recourse to appeal in the case that it is denied. And even that participation through an amicus of communities is very difficult because there are a lot of obstacles to filling amicus briefs, and there are restricted narrow conditions and contingent on arbitration discretion. Even when admitted, tribunals are not obliged to consider amicus arguments. More generally, human rights and environmental considerations have also not received adequate weight for arbitration tribunals. This has been recognized by the working group on the issue of human rights and transnational corporations and other business enterprises on its 2021 report. And again, Ecuador is not the exception, because this is an example where directly affected communities were excluded from ISDS processes. Communities and civil society organizations, as soon as they learned that this process was ongoing, applied to submit an amicus brief, arguing that these actions taken by Colombia were justified by the state's human rights obligations. Nonetheless, the tribunal refused to admit the proposed submissions. It is worth noting that in some cases, such as, for example, the Glencore dispute, which is still ongoing, persistent efforts by communities, by organizations like AIDA or CAJAR have led to the acceptance of participation as non-contending third parties representing indigenous interests. However, it is important to bear in mind that this outcome is the exemption rather than the norm. The third criticism that we can find is the lack of transparency and the no binding precedent system. ISDS cases are frequently conducted behind closed doors with limited disclosure of documents. This secrecy impairs accountability with fundamental public interests, like, for example, in the case of Santurbán, water security for the communities. Even when the water security is at stake, they cannot have the direct access to the information. The working group that I was referring to on the issue of human rights and transnational corporations in 2021 warns that this inconsistency undermines legal certainty and can confuse the states about how to regulate without risking claims. For example, in Ecuador, the tribunal interpreted ACET, Article 2201 of the FTA, so that environmental measures, even if taken in good faith, did not preclude a compensation obligation. In contrast, in David Heaven versus Costa Rica, an arbitration tribunal ruled that investors' rights are subordinate to a state's rights to ensure that investments are carried out in an environmental sensitive manner. Hence, while Ecuador favored investor claims, even when environmental measures were clearly justified, in the case of Costa Rica, the tribunal affirmed the primacy of environmental protection over investor expectations, completely the opposite thing. And this inconsistency and this lack of a binding system of precedents can also be evidenced in cases against the same country. In Ecuador, for example, the majority found that Colombia's failure to delimit the Santurbán Páramo due to and I quote, complete lack of agreement or coordination among competing ministries resulted in an unjust and arbitrary frustration of Ecuador's legitimate expectations. The tribunal characterized this as a failure of the state to resolve its competing demands for environmental protection and economic exploitation. Conversely, in the Red Eagle case, one of the three cases that I was mentioning, the tribunal concluded that the unpredictable or instability in the state's policymaking was an inevitable outcome given the complexity and real-world difficulties of balancing legitimate objectives such as economic exploitation and environmental protection. In this instance, the same kind of regulatory uncertainty was not deemed arbitrary. It was on similar facts against the same country with completely different assessments of the situation. And the fourth aspect that I would like to highlight is the regulatory chill that is going to be assessed in depth by Juan. But for example, Colombia, although a law was approved in 1993 that established that páramos are subject to special protection, it took until 2010 and 2011 for mining prohibitions to be introduced in these areas. And after several attempts, it was not until 2024, last year, that civil society finally secured the approval of Decree 44, which sets criteria for declaring temporary reserve areas to prevent páramos exploitation. So, despite the efforts of organizations such as the committee to which Juan belongs, disputes over the delimitation of the páramo continue, which exemplifies how the The threat to costly arbitration and the risk of ISDS claims may have induced to a regulatory chill that hinders decisive environmental actions. So in conclusion, so I can yield the floor to Juan. While Colombia protective measures in the Santurbán Páramo sought to address urgent ecological and social needs, the Ecuador Award illustrates how the ISDS system can complicate these regulatory efforts by four principal criticisms. The predominant focus, as I was saying, of the investor rights, the lack of effective community participation, the due process concerns, and the regulatory chill. Having said that, let's hear to Juan, who is going to present and give us his testimony on what are the obstacles that he has to face and the committee has faced to protect the páramo of Santurbán. Juan, please.
Gracias, gracias, muy amable. Buenas tardes a todos los compañeros y a todos los asistentes, a todos y todas.
Thank you very much, and good afternoon to all of you. And on behalf of the Páramo, well, thank you very much to all of you to allow us to be here with you. This has been a huge, very important experience we had. And Minesa Mudara, it by the minority titles to another company, Greystar, also Greystar that now is called Eco Oro. And this is a financial holding belonging to the royal family of the United Arabian States. So I will, can you hear me well? I will share my screen with you. Can you see my screen? So, I'm Juan Bautista Tavera Salamanca. I'm an economist. I'm specialized in public gestion and union activist. And my colleague, Sebastián, already talked of what a páramo is. I will talk a bit more in detail. So those are pictures of the páramo. The páramo is on the Andean mountains. And this specific ecosystem is seen in Colombia. We have many páramos, Cruz Verde, for example, and they all give water to Bogota. And we've seen that due to the climate crisis in Bogota, we are seeing water issues because now we have less rain, and that is why the páramo has not the capacity it has before and is not able to provide all water needed in Bogota. So this is the ecosystem which is very linked to the other ecosystem, the sub-páramo ecosystem. The Santurbán Páramo has a specific fauna and flora. It's a fractured rock with a lot of water. We can see that in Colombia, but also in Venezuela. The Zulia River that is linked to the different rivers in Venezuela. So here, this páramo gives water to more than 3 million people in Colombia. We also have another one in Cúcuta and others in 37 small communities in Colombia.
parásitos que extraen del páramo almorzadero. Entonces, es de una importancia esencial para nosotros.
This
Porque
ecosystem
es
is
la única
very
fuente
important for us.
de
It's the
agua
only
potable que tenemos nosotros los santandereanos, perdón.
drinkable
Que nosotros
water
conseguir
we
en cualquier
have, a
parte
source
del
of
mundo,
drinkable
pero
water we have in
nosotros
Colombia,
estamos
in
viviendo
Bogota.
actualmente en el páramo de Santurbán,
So
que
it's
es
very
la única
important for
fuente
us
que
to
tenemos nosotros los
defend
colombianos
that
para proveernos de agua,
páramo.
¿sí? Entonces aquí estamos viendo, por ejemplo, lo que es
And
el
here
impacto de la
we can
minería
see
metálica en los
the
páramos,
impact
y
of
quisiera
minery,
permitir que la minería, la megaminería que pretenden las 6 multinacionales
the
por modal la minesa, y en este momento Iris Mining,
we have, for example,
se quiere
Iris
que
Mining,
el proyecto megaminero sea a cielo abierto, está
that
subterráneo,
have a mega
concesionarias,
project of
liberación de
open
elementos
minery,
tóxicos y radiactivos que
and
pueden
this
afectar a la
can
flora y fauna, como lo
be
señala
very dangerous for the
especies
fauna and
endémicas,
flora.
y el agua, por ejemplo, allá en forma natural, sin necesidad de que se lleve ahí molibdeno, mercurio,
We have
arsénico,
molybdenum,
bario, cianuro,
mercurium,
uranio, en fin, una serie de...
and a lot of,
Tenemos aquí un experto que se llama Gonzalo Peña que dice que en
well,
el páramo
our
de Santurbán
expert
descansa la tabla periódica,
Gonzalo
ahí en las entrañas del páramo de Santurbán, además
says
de que
that a
está
lot of
el agua de la minera.
dangerous
Hay
product
un
can be
hermoso,
found.
así como llamado un hermoso milagro natural, en donde
And
mientras esos metales y esos minerales no tengan
those
contacto con el aire, no van a
dangerous
oxidarse, no va a
minerals,
producir un elemento de oxidación y nos va a contaminar el aire
and
y el agua. Entonces,
they
allá en
won't be
terraníos, allá en
polluting
su
if they
suelo
do
deben
not
estar.
enter in contact
Entonces,
with
esa es una razón
air.
importante
That
por
is
eso
why
es tan sensible y tan frágil el páramo de
this
Santurbán.
ecosystem and
Si
this
no fuera así,
páramo is very
el páramo de
fragile.
Santurbán también habría una contaminación del agua superficial y subterránea, es decir, de los
We
acuíferos,
also have
que surten
a
de agua
pollution
accesible a más de
of
3 millones de colombianos. Al romper la dinámica
the
de
superficial
las aguas superficiales y
waters.
acuíferos, es decir, que es lo que estudia la hidrología y la geología, este
And
es, por ejemplo, un esquema que
this
tenemos
is,
aquí
for
de lo que
example,
es la
here a
dinámica hídrica,
picture
¿sí?
of what
Donde
is
todos
the
sabemos el agua
hydric
circula en sus diferentes
dynamics.
estados, de las nubes,
We
llueve,
can see
cae
here
al páramo, las
the
montañas son
rain,
absorbidas y
falling in the
transformadas por las rocas,
paramos,
como ven que
the
son fracturadas y
forest,
alimentan los acuíferos. ¿Qué se necesita que haya
etc.
para que
So
haya agua superficial? El agua
this
superficial es
is
solamente el 10%,
this is
el
essential
90%
for
está
the
dentro del páramo de
superficial
Santurbán.
water,
Es decir, se
and the
necesita
rest
que
of the
los
water
acuíferos estén
is
saturados,
inside the
tengan
paramo.
muchísima agua para que pueda haber agua superficial. Como les
So we
dije
need a lot
anteriormente,
of
los
water
páramos
in order
tienden a
to have
vomitar cuando ellos
superficial
están
waters.
sufriendo estrés hídrico, es porque están alteradas, han
And
disminuido los regímenes de vida, por lo
nowadays,
tanto los acuíferos
because
también bajan
we
su cantidad de
have,
agua, que
because
eso
of
hace que
this
también fluya
rain
menos agua hacia las
problems,
superficies.
we do not
Este es
have
el estrés, esta es la
much
dinámica
water and we have
hídrica,
less
y esto es lo que
superficial
sucedería. Esta
water.
imagen es lo que sucedería en
This
una
is
minería a cielo
what
abierto.
what
Vean
can
ustedes el
happen,
esquema anterior,
sorry.
¿cierto? De aquí para
So
pasar
we're
acá.
going
Esta es una
from
minería a
this
cielo abierto
to
que produjo la
this.
Greystar,
This
¿sí?
is an
Y
open
cuando ellos llegan
sky
al páramo lo encontrarán
minery
así y nos lo quieren dejar así. Cráter lunar,
site.
esto es un cráter que tiene aproximadamente 500 metros de profundidad y tiene un
This
diámetro de
has
2 kilómetros
around
de diámetro.
500,
Esto es,
is
por ejemplo, una
500
imagen
deep,
de
more or
otros
less.
desastres ambientales que ha generado
And
la
this
minería
is
subterránea a
what
cielo abierto. ¿Cuál es
happens
la diferencia
due
con la
to
minería
minery.
subterránea?
So
Que
what's
dejan
the
un cascarón de 30
difference?
metros y ahí hacia abajo
Here we
empiezan a
can see
construir sus galerías.
that they are
Y en esta
starting
tiene proyectadas unas
constructing
galerías
or
de 834 metros de profundidad
mining
por 2 kilómetros
deep
de
down.
ancho, más otros dos túneles para sacar el polimetálico y las tierras
And
estériles,
they
lo que haría
exploited two different
una
tunnels.
inmensidad, pues unas galerías que son tan grandes que en esa
So
galería que pretende construir modada
those
la
are
minesa de
huge
Emiratos Árabes cabría, si el sitio
galleries.
más alto del mundo, que es el Burj Khalifa, cabe 10 veces en las galerías que ellos pretenden construir en el páramo de Santurbán. Es una situación que nosotros no podemos permitir, porque
And this is a
prácticamente nos va a detener
situation
toda
we
nuestra
cannot
vida. Es decir,
allow
no solamente la soberanía hídrica, como decía la
because we
compañera,
need
sino
our
es la soberanía
hydric
agroalimentaria, es la
sovereignty, but
forma de vida, es nuestra
also
vida misma,
food
si
sovereignty.
permitimos
This
pues
is
que
essential
llegara a
to
la
our
superficie.
lives.
Entonces, volviendo a los argumentos, entonces,
And
al romper la
when we
dinámica
come back
hídrica, pues
to
nosotros
the
tendríamos que
different
desplazarnos.
arguments,
Tendría
so
aquí un desplazamiento de más de 3 millones de personas para
more
eso.
than 3
Eso
million people
porque si nos permitimos que nos
will
contaminen
have
el agua.
to
Otro es que se generan unos pasivos ambientales a
live
perpetuidad.
elsewhere
Sí, haría agua
if we
contaminada,
cannot
como le dije
stop
anteriormente,
this
con minerales
problem.
tóxicos y radiactivos, y en este momento no existe
And
tecnología para liberar
right
el agua
now,
de
we
esos
do not have
residuos
the
tóxicos y
sufficient
radiactivos.
technology
Ustedes
in order
recordarán que los desastres
um,
nucleares que han sucedido en Chernobyl, Fukushima, en Japón,
to
toda esa serie de cosas, esas
depollute
tierras
these
han quedado contaminadas con
waters.
radioactividad a perpetuidad. Si nosotros permitimos que eso
And
nos
if
suceda,
we
y se libere
allow
uranio y
that and allow uranium, for example, to get liberated from the páramo, this will provoke a huge problem. And now we have also illegal minery that also led to violence, alcoholism, prostitution, etc. And all this is, all the minery is goes to the river next to the páramo, and so this is a tragedy we must avoid. So this mega project, in this project, they create a huge camp, and they do not, for example, buy things from Bogota or from the villages next to the camp. And a lot of water sources have disappeared right now. And in the higher part of the páramo, we have lakes, and those lakes are now dry. And this, if we let the situation go, this will have huger impacts. We have a huge mega project, and if we let them do, this will have an impact on the rivers next to the páramo, the Tona River and Frio River, because all the water of those rivers come from the páramo, the Santurbán páramo. Here we can see the Mohammed bin Zayed prince. He is speaking with Juan Manuel Santos, the former president of Colombia, that was also given the Nobel Prize. And this has a huge impact on our region and is threatening our lives. What have done the Canadians? Well, they've also brought to court when they bought the mineral titles. There was already existing an environmental legislation forbidding mega mineries on those sites. So they already knew that norm, that law. So they sold their titles. And Ecuador couldn't prove that they invested more than $7 million US dollars because they didn't build a huge camps or huge ways. So LACEI said that Ecuador knew this environmental legislation and they all wanted to destroy the life of the páramo.
They can sell the mining titles from Santurbán, but Anyways, they knew they exist and they were damaging a strategic biodiversity system for food safety and food sovereignty in this region. So finally, well, we think it's perverse, these tribunals, because the free commerce treaties are signed among two governments with two different court systems. They need to create a parallel justice device, which is very perverse, because these international courts, they don't recognize the two systems of justice of the two countries that signed the treaties. And they don't hear the local communities, they don't recognize the Colombian legislation and the other countries that are signatories, in this case, the Canadians. So they want a system to support them, and this is something that is perverse. And these courts are paid by the mining companies. This is how, if you go to a football play and you know that one of the teams is paying to the referee. We know someone is paying for this court. So for us, it is other of the things that are presented, the social fracking at the local level. They bought awareness, they bought souls of the politicians and of the businessmen here at the local level that are favored to this kind of investment. So we who stopped the work in the Santurbán Páramos are we, the people, the community. We went to the streets, we make demands in the different court systems here to be heard in the streets and by the community, and that allow the defense of the state to take action, because we help them to have the argument as it should be against the abuses of the multinational companies. So we think the demands are this government from President Gustavo Petro allow us to review these treaties, TLCs, from the right, and they allowed the multinationals to come here and to abuse of the environmental conditions, to abuse our environmental legislation in favor of the multinational mining to have. One of the cases to finish is that last year the multinationals demanded into the Constitutional Court that they have the right to take the cost and to receive the profits that they should pay to the Colombian state, but the lobby, multimillionaire lobby that they made in the communication media, they win to the Colombian state this process in which the Colombian state should give back to them part of their profits. So as our taxes, we are subsidizing like a percentage of the profits. So we are subsidizing the multinational companies with our taxes. And at the end, they threaten us and they turn us back to the colonialism. And other strong consequences is the expulsion of people that don't only affect Colombia or the countries that are receiving investments. We see that Europe and United States are receiving lots of immigrants, and they show that poverty is multidimensional because the origins of them are multinational. It's not only poverty, but it's also environmental disaster that makes the masses of poor people to move to other states to look for a better quality of life. And the multinational companies, they they make environmental disasters, they create
Wow.
environmental disaster in our countries, and they have to receive the results. Thank you very much.
Thank you. Thanks so much,
Right.
Juan. That was really informative. And I was particularly struck by one of the points that he made at the end there, which was that so often these ISDS cases are brought after a social movement has had a victory, has managed to, beat back some kind of corporate abuse, and then they come back with the ISDS case. I can see there's a few questions that people have asked in the Q&A. I think some of those Cleodie is going to definitely address in her presentation. There was also, I saw that we've obviously got some very informed people on the call as well, because somebody answered in the chat there a question which was useful. So let's keep doing that. But what I'm going to do now is introduce Guillaume Long. He's currently a senior research fellow at the Center for Economic and Policy Research in the US, and as I said before, served as Ecuador's Minister of Foreign Affairs in the government of Rafael Correa, during which he oversaw the termination of the country's bilateral investment treaties due to the threat, this exact threat of investor-state dispute settlement to the country's sovereignty. His research now includes foreign policy, regionalism and integration in Latin America, and the Colombian conflict and peace process. So welcome, Guillaume, and take it away.
Thank you very much, James, and thank you all for being here, and thanks to Global Justice Now for inviting me. It's a pleasure to be with you. I also, quiero mandar un saludo a las compañeras y compañeros que están
I
luchando.
also want to say greetings to the people that are struggling against the large corporations' abuses.
Corporate abuse. It's an ongoing fight. It's a tough one, particularly in the new current circumstances, with a lot of oligarchs ruling in the world and in influential countries too. So, I mean, I'm going to talk mostly about what we did in Ecuador to be able to exit these egregious corporate courts, this ISDS mechanism. Maybe some of this applies to Colombia, and I do think Colombia is at the forefront right now of the battle against this corporate abuse and these corporate courts. I really think this is there is a big debate taking place inside Colombia, and of course, because of Juan and Sebastián have just given us a clear explanation of why Colombia and Colombian communities are at the forefront of this struggle. Now, some of what I'm going to explain here may apply, some stuff may not. I think it's important to say that we gave this fight starting with a constituent process. So fundamentally, thanks to a new constitution, which was approved in a referendum in 2008 in Ecuador, and that constitution gave us Article 422 of the Ecuadorian constitution, which explicitly prohibits arbitration for investments, so these corporate courts. Although there's been a lot of debate trying to interpret that article, it's essentially extra-regional arbitration, so arbitration outside of the region, and the region is understood here as South America. So there've been attempts to try and interpret that to bring back, I'll talk about that in a minute, but to bring back arbitration and corporate courts through this kind of regional interpretation. I certainly think, just before I start on Ecuador, I really think there is a lot of global momentum on this. I think well, I mean, first of all, there have been a number of countries that have left ISDS mechanisms, that have abandoned these corporate protection mechanisms, these corporate courts. South Africa, of course, is an important case. India as well, Indonesia, and of course in Latin America, Bolivia, Ecuador, and Venezuela at different points in time left these courts. More recently, Honduras. Honduras is a really important country in this struggle because it's facing one of the, I think it might be the largest arbitration case in history in terms of amounts of money. It's $11 billion arbitration against the Honduran state. I've been doing a lot of work, and I know some colleagues on this call have also been involved in Honduras, which is another sort of battleground country in the fight against this corporate abuse and these corporate courts. But actually also there's a lot of momentum because, as many of you know, in the advanced economies in the global north, if you like, there is a rethinking of this. And there's a rethinking of it. We saw it in the first Trump administration and in the Biden administration as well in the United States. It's not a total rethinking of it, but there's some rethinking taking place. And we're seeing it in Europe, in the UK, and in the EU with this withdrawal from the Energy Charter Treaty, right? Now, the problem is, and this is the problem that Colombia faces and a problem a number of countries face, including in sub-Saharan Africa, there's a lot of do as I say, not as I do, right? So, you know, whilst, you know, the UK and European countries might be withdrawing from these corporate courts, they're still telling developing countries to stay in these mechanisms, to not denounce these investment treaties, to not abandon these corporate courts. So, you know, a lot of European countries are abandoning the Energy Charter Treaty because, as was expressed here, it prevents, you know, the energy transition, and it goes against the Paris Accords. But they're still telling, and I know, I mean, even in Ecuador, in my country, some European, in fact, heads of government have traveled to Ecuador the same month they were withdrawing from the Energy Charter Treaty, telling the Ecuadorian authorities, you have to sign this little treaty here, right? You have to, despite the fact in Ecuador it's now unconstitutional. And that's because Europeans still want to protect their large corporations, and they want to do this by making sure that developing countries do not withdraw from these ISDS mechanisms, do not withdraw from these corporate courts. So a lot of double standards, but certainly a new debate, which wasn't really on the agenda 20 years ago. Even when we did it, it was more difficult, I think, than it is now. There's a lot more pushback at the international level against this form of corporate abuse. And we have to use this window of opportunity. And I think Colombia is a real battleground. So how did we do it in Ecuador? Well, we had this new constitution, which was you know, the base of everything we did after that, because we could argue it's in the constitution, therefore we have to develop these new laws, and then we have to develop a new national development plan, and we have to develop these new policies. It's all a new constitution. The constitution was ratified by referendum, and this was sort of you know, the path to be followed, and which we did follow for 10 years. We always had the constitution in our hand, arguing this is what the Ecuadorian people want, and this is what we're going to do. And I think it was that gave us the legitimacy of a new social contract. So in 2008, the new constitution. In 2009, we left ICSID, which is the World Bank arbitration mechanism, the corporate court of the World Bank, if you like. And it's one of the largest ones. I think it's one of the biggest ones. Certainly in Latin America, if you leave ICSID, then that's, you know, a big hurdle. But then you have all the bilateral investment treaties. And these bilateral investment treaties, in the case of Ecuador, we had 26 with 26 countries. So an investment treaty with each one of these 26 countries. And it took us another 8 years from 2009, when we withdrew from ICSID, to 2017, which is when I, as foreign minister, denounced the last 16 bilateral investment treaties in one swoop. And those were the most difficult ones, because the first 10 were bilateral investment treaties that we managed to get rid of sort of in mutual agreement with countries. I mean, some of them were with countries where there was no investment. We even had a bilateral investment treaty with Bolivia, you know. Nobody really knew, neither the Bolivian government nor the Ecuadorian government, why we had this bilateral investment treaty. So those ones were kind of easier to withdraw from. The harder ones were, of course, the big ones, you know, the one with the United States, with the UK, with Germany, with France, with Spain, with China, with, you know, and we announced all of these, the one with the US, but also the one with China. We exited all of these bilateral investment treaties, and I have the honor of having sort of put an end to those treaties. Of course, then that withdrawal had to go via a constitutional court. It had to be ratified by our Congress, our National Assembly. So it was a drawn out legal and political process. I suppose after withdrawing from ICSID, the CIADI in Spanish, we've heard of the CIADI here on this call already, ICSID in English. One of the big triggers was the arbitration case brought against Ecuador in ICSID by Occidental Petroleum, known in Ecuador as Oxy, a big US oil corporation. And I think this is it was the largest, I mean, certainly as far as we knew, it was the largest arbitration case brought against any state in history at ICSID, 2.3 billion. Now it's been dwarfed by others. But back then in 2012, I mean, and Occidental Petroleum won that case for 2.3 billion against Ecuador. And it was just an egregious ruling. Basically, it was based on the fact that Ecuador had terminated the contract with this oil company, Occidental Petroleum, based on the fact that the company had illegally entered into a subcontracted another company. So basically it passed over its activity in the oil fields to another company, a Canadian company called Encana. And it had done so without even asking permission from the Ecuadorian state. It had done so without even warning the Ecuadorian state, without telling the Ecuadorian state. We're just passing these oil fields, which belong to Ecuador, to this other corporation. So Ecuador put an end to the contract. And in fact, ICSID didn't even rule that what Ecuador had done was illegal. It was what Occidental Petroleum had done was illegal, and the court agreed with this. And so, Ecuador was in its right in doing so. But the court, the ICSID arbitration court, decided that the Ecuadorian government had acted excessively. That the termination of contract was an excessive move. And it was so horrendous. $2.3 billion for Ecuador was massive. Back then, it was probably, 5% of Ecuadorian GDP. Now it's less. It was a massive thing. So really, this was when we decided to really act upon the constitution more aggressively. There was President Correa launched what became known as the CAITISA, which was an audit commission which would do an audit of Ecuador's bilateral investment treaties, essentially. And it was, I think this is very relevant to Colombia, and I'll say a little bit more about this in a minute. But the audit commission was largely foreign, so it was a majority of foreign experts who came to Ecuador to audit the situation with all these bilateral investment treaties. And it did so between 2013 and 2017. I mean, the report came a little bit earlier, but it finally presented the report to the president in 2017, so 4 years later. And it was presided actually by Cesar Gaviria, a very important Colombian politician who has since left us, but who was also a candidate to the presidency in Colombia. And then by Cecilia Olivet. Anyway, the CAITISA was very important. There were a number of conclusions in the report, but three main ones, I think, that I'll mention here. The first, and this is very important, it could be very relevant to Colombia also, although I think maybe slightly less because Colombia has a slightly more solid juridical system than Ecuador had, and a few more checks and balances. But the first conclusion was that many of these bilateral investment treaties, in the case of Ecuador, had been entered into illegally, if you like, violating even the prior constitution, that they weren't, in a number of instances, these treaties were not ratified by Congress, which made them illegal, which made them null and void in the first place. Now, this is something that you could do in Colombia. You could have an audit of whether a lot of the bilateral investment treaties are in fact legal from the outset, whether they were entered into in a legal fashion. So that's the first thing we did. The second thing, the second conclusion of the CAITISA, this audit commission, was that, basically it was a calculation of costs, of how much all these cases against Ecuador were costing, whether, the relationship with the investment in the first place, whether Ecuador made money out of these bilateral investment treaties or lost money from entering these bilateral investment treaties. So there's a more economic analysis. And the third conclusion is whether investment actually came to Ecuador as a result of entering these bilateral investment treaties. And of course, the whole leitmotif, the whole idea behind signing bilateral investment treaties for states is to attract investment, right? Investors say, oh, they say, you don't have bilateral investment treaties, I'm not going to invest in your country, I'm going to invest in your neighbor's country, and this whole race to the bottom, which is this blackmail, right? Which is the way that they get countries to sign and ratify these bilateral investment treaties. And so the CAITISA wanted to check whether, it had actually encouraged investment in Ecuador. And the conclusion is really stark. There is no significant increase in foreign direct investment in Ecuador. There is an increase, but there is no change of trend in that increase from the moment you start signing bilateral investment treaties. So it didn't actually succeed in increasing the rate of foreign direct investment in Ecuador. And all it did is give these companies extra protections and impunity, essentially. And that's the first point. And the second point, of course, is that the idea behind signing bilateral investment treaties, and this is how it was sold to the Ecuadorian public, was to increase investment in the non-oil sector. Why? Because Ecuador already knew how to do oil. Ecuador had a big oil company called Petroecuador. It had been drilling for oil since 1968, first Texaco, and then Petroecuador came in. So there was a lot of, there's a lot of Ecuadorian professionals in the oil sector. Ecuador knows how to drill oil and export oil. But what Ecuador wanted to do is attract foreign direct investment in other areas of the economy in order to diversify economy away from this sort of heavy dependence on extractivism and on oil exports in particular. And what do we see? We see that all the FDI that came to Ecuador, all the investment that came to Ecuador is still basically extractive investment. It's still in the oil industry. So it failed on all accounts. It doesn't increase the amount of investment, and it doesn't, crucially, diversify that investment. So those were the conclusions of the CAITISA, and those conclusions, of course, by these experts were fundamental in order for us to be able to withdraw from 26 bilateral investment treaties. Now, since 2017, Correa was in power between 2007 and 2017. There have been a number of right-wing governments in Ecuador. We're on our third one now, Lenín Moreno, Guillermo Lasso, and Daniel Noboa. And those governments have tried to return to ISDS mechanisms, tried to return to, well, there was even Lasso returned us to ICSID, to the CIADI, to ICSID. And there have been attempts to interpret the constitution to be able to go back to these corporate courts. It's not been that straightforward because we have Article 422 of the Constitution, right? So that's really important to try and enshrine this in law, to enshrine this in constitutional reform is a padlock you put in place, and that protects you for the future. However, Daniel Noboa last year, frustrated that he couldn't reintroduce ISDS, organized a referendum in Ecuador, a referendum, no more, no less, in April last year, and asked the Ecuadorian people whether they were agreeable to changing, whether they agreed with changing Article 422 of the Constitution, to scrap it essentially, and to reintroduce the possibility of these corporate courts. And incredibly, I mean, it's the complex issues, right? Arbitration, these are very techie subjects. When you're putting this in a referendum, this is not a simple issue to explain to people, and yet Ecuador, the Ecuadorian people, I think heroically voted 65% against the president's proposal and denied the possibility for reforming or scrapping Article 422 of the Constitution. So there's a lot of frustration right now with Ecuador because Ecuador managed to uphold this ban on corporate courts on ISDS. Having said this, we now know that Canada and Ecuador are in a process of putting the final commas to a FTA, a free trade agreement, which has already been announced by Canada, and the Canadians have already announced that it includes ISDS. So incredibly, Canada and Ecuador, of course, under Novoa, but that's maybe less of a surprise, are violating the Ecuadorian constitution, are going against the will of the people expressed only last year, April last year, in a referendum, where explicitly 65% voted against this. So we're now waiting for publication of the final treaty, and of course it will have to be ratified by Congress, Parliament in Canada and Congress in Ecuador, and there'll be another fight there. But it's really incredible that despite the fact that it's banned in the constitution, these countries are still signing free trade agreements with ISDS clauses. Okay, so just to wrap up, I think in the case of Colombia, there is a real opportunity. There's a real debate inside the government. It's not a simple situation. We had that in our government as well. You're always going to have sectors of Colombian society in favor, against. It's a political battle. But I think civil society, and there's lots of civil society on this call, can really start a campaign. I really think one way of starting, I mean, there are a number of ways of starting a campaign, but one way of starting a campaign is through this idea of an audit. So you're not necessarily saying, withdraw now immediately from all these bilateral investment treaties. You're actually saying, let's audit them. You can do it in the way Ecuador did it, was by bringing experts from abroad. You don't necessarily have to have a majority of government officials in the audit. That makes it more independent. It makes it more technical. It makes it more serious, academic, if you like. I'm sure that in the case of Colombia, just that everywhere else in the world, the conclusion will be most likely that it's been very detrimental to the Colombian economy, to the capacity for the Colombian state to carry out public policies. It's detrimental to labor rights. It's detrimental to human rights across the board, of course, and it's detrimental to the environment and environmental rights, right? Because it gives impunity to these corporations and to big capital. So I think that's what I would encourage you all to do, to try and get the Colombian state, Colombian institutions to do an audit to see what has really happened. How have these bilateral investment treaties be signed, incorporated into Colombian law? What are the economic costs been of arbitration and these corporate courts? And has there really been an increased investment, and what kind of investment and in what kind of sectors? I think I've gone on for too long. These are the kind of lessons that have been learned from Ecuador. There may be just one last word. There's an important lesson to be learned from Honduras, who's just withdrawn from ICSID and is facing an egregious arbitration case in ICSID for $11 billion, which is equivalent of a third of its GDP. And this is for basically putting an end to the ZEDES, the Zonas Especiales de Desarrollo, in the special free ports and free zones in Honduras. Again, and this may be relevant to Colombia, in the case of Honduras, the campaign started with Xiomara Castro's presidential campaign calling for a no to ZEDES, right? And this was a key pillar for her electoral campaign, and she was elected on that platform, and then she became president. She was forced to deliver. This may be also relevant to Colombia, maybe even in the next presidential election, for civil society to make this a crucial component of the presidential election and of the legislative election, so that it really becomes politicized and really becomes something that politicians have to deliver on if they're elected. Thank you very much.
Thanks so much, Guillaume. And you really covered not just the kind of case for and the detail of how you did it in Ecuador, but I think some of the kinds of key questions that people come back with. How does this, isn't this going to affect, if we pull out of these, isn't this going to affect investment and so on, which, yeah, that was really useful. I have, before we could just go on to Cleodie to explain what exactly we're doing in the UK. It's great to see that we've got some people joining us from Colombia and elsewhere. Obviously, I mean, Colombia has a number of these investment treaties, right? As does the UK, but in the UK, we'll be focusing particularly on the UK treaty. So Cleodie's going to explain that. And I've just posted, if you look in the chat, a few messages up. I posted a link to our little booklet that explains if you want to go away after this talk and reread and understand and get involved, obviously, which is the crucial bit. So, and I also just wanted to say hi to the people who have a watch party for this webinar in North Berwick, which is in the Lothian East constituency, which is the constituency of the UK's Trade Minister, Douglas Alexander. So we're hoping that they'll be able to put some particular pressure on him over this campaign. And that's why our Scottish office organised that little gathering. So anyway, without further ado, Cleodie, take it away.
Thank you. Can you hear me okay? Yeah, good. Seeing nods. Yeah, I'm Cleodie. I'm the trade campaigner here at Global Justice Now, and I'll try and keep this brief because we've heard from the kind of direct experiences from on the ground in Latin America and in Colombia, and from some real experts who've been really involved in these processes. And I know you're probably all now really wanting to hear what exactly we can do on the ground in the UK to act in solidarity with these movements and processes in Colombia. I think what we've heard from Sebastián and Juan is about how necessary it is to act on the ISDS system, especially when it comes to Colombia. And what we've heard from Guillaume is that it's possible. It's difficult and we face lots of backlash and but it is possible. So I just want to zoom out a bit because we've heard about these specific shocking cases in the Páramos in Colombia, but just to give a slightly broader context and why we've chosen as Global Justice Now to really focus in on the UK's treaty with Colombia is the number of claims that Colombia is facing from the last decade. And it's no surprise it's really come at a time where Colombia is really making strides away from the fossil fuel past. It's lots of you will know that in our climate campaigning we're working on something called the Fossil Fuel Non-Proliferation Treaty, and Colombia has become one of the first producer countries to endorse this treaty. And the overwhelming number of cases that have been raised against Colombia are by multinational mining companies in almost direct response to measures they've taken to protect the natural environment, to protect human rights, the rights of indigenous peoples. And besides this huge financial burden, Colombia's pending claims are more than 13 billion. The threat of these cases works to create a chilling effect, as Sebastián was explaining, making countries like Colombia, have to really think twice about introducing such progressive legislation. We've heard a lot about the Ecuador case. That's actually one under the Canadian treaty. So just to explain one under the UK treaty in particular, there's 4 current cases under the UK treaty. One of them is a really good example of something called treaty shopping, where the ultimate owner of this massive nickel mine in Colombia called Cerro Matoso is a Australian mega mining company called BHP Group. Australia doesn't have access to, Australian companies don't have access to ISDS via Colombia's agreement with Australia. So BHP is using a UK spin-off company to sue Colombia over a tax investigation it carried out into the Cerro Matoso mine for allegedly not paying royalties it owed to the government of 152 million. And so now there's this case for 94, they're suing for 94 million under the UK treaty. And we also just found out in January this year that there's a new case under the UK treaty from a private equity firm suing Colombia over a highway construction project. We don't have much details about that. As with lots of these cases, it's very hard to unearth the details. given how secretive the system is, but some news reports suggest that it concerns Colombian legislation protecting water springs along this highway route. So that's a bit of background, just to explain some progress and developments we have had in the campaign so far. At the end of last year, we hit this milestone where the Colombian trade minister announced publicly in an article in the Financial Times that Colombia would be seeking to renegotiate the UK-Colombia investment treaty. And this came after we'd had a few meetings with, for example, the Colombian ambassador to the UK, providing some briefings on this issue. And he came out and called these treaties a bloodbath. And shortly after, we saw the president of Colombia announcing that they were looking to extricate Colombia from the threat of corporate courts in its trade deals, looking first at the US and the EU, and then we got this announcement about the UK treaty in particular. And these steps have been really driven for a long time by the social movement, some of who have joined us on this call in Colombia, whose resistance to corporate abuse, corporate destruction, from the Páramos of Santurbán to the Wayuu people fighting the huge Cerrejón coal mine in La Guajira in the north of Colombia. Their wins have been threatened and caught up by these this sort of slew of ISDS claims. Lots of you will know that in May last year, we joined a delegation of different European and Latin American organizations to bear witness to some of those struggles and start to build some more solidarity between the countries being sued and the countries that are home to lots of these investors that are doing the suing, and to support Colombian movements who are calling on their government to exit from ISDS treaties. So now that the deal has kind of been putting much more on the table, as part of that solidarity, we really need to respond to that by ensuring our government comes to the table and acts in good faith. And it's a challenge, but we also have some wind behind us. As James explained, we won our campaign to get the UK to join the Energy Charter Treaty. And now is our moment really to call out the hypocrisy of the UK citing the risk of ISDS to our climate policy here, and then still lording it over our trading partners. And we have a certain procedural opportunity with this treaty, given that the deal passed its initial 10-year term last October. So it was signed in 2014. It has 10 years where it's basically its provisions are locked into place. And then after that, it rolls over, so it automatically renews, but either party now has the ability to kind of open it up again, renegotiate it or terminate it. The issue is it has one of these sunset clauses, which means that only a mutual agreement between the two countries could neutralize the sunset clause. So if one party unilaterally decides, so by itself decides to leave the treaty, its terms will still apply for 15 years, which is why what we're really calling for is a bilateral termination of this treaty. So for the UK to sit down with Colombia and agree together. So yeah, given the number of egregious cases against Colombia, given the efforts its government is taking to exit the system, the UK-Colombia deal is our sort of first step in our broader demands of the UK government to extend the stance they took on corporate courts in the ECT, the Energy Charter Treaty, to extend that across the board and ultimately commit to no more ISDS in any future agreements, and to review its existing stock of investment treaties. And, you know, if we can support Colombia to take one further step out of the ISDS system, we can add more momentum to this growing trend of global South nations standing up to these really toxic deals. And, you know, in terms of things how we're getting this going on the ground in the UK, we're working with a wider group of UK organisations. Some of you will know, you know, lots of partners we work with in the UK, such as War on Want, London Mining Network, Trade Justice Movement, and also with some Colombia solidarity organisations that exist here in the UK, such as AB Colombia, Justice for Colombia, to kind of build a much broader civil society demand around this treaty. And we're building parliamentary support in the House of Commons, in the House of Lords, to pressure the government to act, especially at this very crucial time where the UK is developing its trade strategy, and its stance on ISDS is quite up in the air at the moment. And we're also connected to Colombian movements working on this issue, and we've been helping to brief officials in the Colombian Trade Department on how to broach the deal with the UK. We've been talking about this sort of proposal that Guillaume has brought about doing these kind of comprehensive audits of government's kind of whole stock of investment treaties, but we're also really also platforming the UK treaty as being what could be more of a test case in how to kind of extricate from deals that are slightly easier to open up. You know, Colombia has these big free trade agreements, for example, with the US. An investment treaty kind of narrowly deals with investment flows, so you don't have to open up all these other chapters as part of that negotiation. And we've been intervening in the media, and at the moment, very excitingly, our youth network, some of our youth activists are planning a sort of eye-catching action in central London. So keep an eye out for that on our social media in the coming month. James has been sharing in the chat. We have some new materials, like an 8-page booklet and a petition flyer, which you can read or distribute locally. We have an online action, which I'm sure actually lots of you on the call have taken, because over 10,000 people have already written to the Trade Minister via our online action. But now you can go a step further and maybe try and meet your MP to discuss this issue. And we've prepared a parliamentary briefing that you can give to them. And we're also currently preparing a sort of talking points cheat sheet that could help you prepare for a meeting, or give you some kind of key arguments and talking points for a meeting with your representative. And finally, of course, it's really important that we share the work and the demands of our compañeros on the ground at AIDA and El Comité de Santurbán. So we'll maybe put in the chat links to some of their Twitter profiles or social media profiles. We have a joint report from the delegation to Colombia, which we joined in 2023, which you can also share. So yeah, that's all the plugs. But basically, I think it's just important to say that it's really daunting, the spaghetti soup of investment treaties that the UK has, but we have shown in the past that we can not only prevent ISDS from being included in deals, but that we've actually got the UK, even under a Conservative government, to leave deals. And if we can tackle the UK-Colombia deal, it's no small thing. It can have a direct impact on kind of fiercely fought territorial struggles on the ground where UK companies are having direct harm, but it could also start to model a process that the Colombians can take forward to advance their ambitions to exit ISDS across all their agreements, and it can give us more ammunition to hold the UK to account, call out its hypocrisy, and to generalize its position on ISDS across the board. So that's my pitch. And I said to James I'd be really quick, but I think I've talked for a really long time, so I'll stop there.
Yes, it was definitely longer than the 5 minutes you
Sorry.
promised it to be. No worries at all. I think that was great. There's not actually a huge number of questions that have come in, perhaps because we were so complete between us in explaining the issue. There was and then I know you've answered a question, Guillaume, in the chat there about sunset clauses. There was another one that asked specifically about how it worked in Ecuador. Obviously, with this campaign, we're trying to ensure that it's a mutually agreed thing, so that we can mutually get rid of the sunset clause as well. Was that in Ecuador? Did you manage to do that, or was that a problem?
No, sunset clauses are a problem, and that's what intimidates a lot of countries to, you know, they think they get caught in this, they don't get out because they think, oh God, I'm going to get all these, you know, all this arbitration is going to come my way. If it's important to bear in mind that if both parties agree to terminate, and this is relevant because of the UK-Colombia renegotiating possibilities that opens, you know, if both parties agree to terminate, there is no sunset clause, right? If both sides say no more treaty, then that's it. The treaty comes to an end. There's no more. But if you do it unilaterally, as we did it, right? You know, we withdrew from these. Well, at least the 16 I withdrew from, and the hardest ones were unilateral withdrawals. Then there is a sunset clause, right? There's a lot of debate as to, you know, the international level as to whether if you've withdrawn from treaties or if you've left ICSID, does that make the situation worse for you, or does that take away the legitimacy of the court, given that the state has already clearly, you know, made it clear it doesn't want to be a part of the mechanism? I'm not sure I can say either, really. It's very difficult. I certainly think that the more withdrawals you have, particularly from ICSID, the weaker the court is and the weaker its legitimacy. And again, I think there is momentum. But yeah, the big backlash are the sunset clauses for sure, which is why it's much better if you can do bilateral negotiation to terminate. And that's what should happen in the case of Colombia, UK, because the UK has withdrawn from the Energy Charter Treaty. It's made it clear it doesn't want to be subjected to this form of corporate impunity, and this is an opportunity to put an end to the treaty. Yeah.
We've also had there was a question here. What's the current status with the Eco-Oro case? We have very little time, actually. So I suspect the answer is, well, maybe it's not that complicated. I don't know. I mean, in some ways, there's a lot of secrecy around these cases, and there's definitely some that go on that we never know about, right? Because there's no obligation for them to be made public at all. But I mean, maybe Sebastián, could you say very briefly? I don't know where we're at.
Of course, very briefly. After the first award issue in 2021, there was another award on issue in 2024 with the damages, and so they have to calculate the cost of the damages that Ecuador have. During this process, during this last stage, Ecuador could not evidence that the restriction of the rights of the concessions that they owe cause a real prejudice, cause jeopardize any investment that they made in Colombia. So at the end of the day, the arbitration tribunal did not issue a compensation against Colombia. It was just about the cost of the arbitration, so they have to pay for the lawyers and all the whole cost of the process, which was around $1 million. But at least the costs were not could not be shown by Ecuador.
Great, thanks. And I'm just going to raise one more question, and you did partially address this, Guillaume, but somebody asked a bit earlier, why would countries sign up to these corporate courts treaties in the first place if they're so egregious? I don't know whether you've got anything else you wanted to add to that.
Yeah, it's called neoliberal ideology, right? It was one of the big tenets of the Washington Consensus, started in the late 90s. Free trade agreements came first, and then this came slightly later. A lot of treaties come from the first decade of this century. 2000 to 2010 was the heyday of these treaties, bilateral investment treaties. And these courts, right, the idea that foreign direct investment is a panacea, which is a whole debate by itself, and that if you give foreign investors impunity, essentially, that they're not going to be tried in your courts, they're going to attract this investment. And I think that's a fallacy. But just one more thing, it's so hurtful in so many ways, not just in economic ways, right? It's a whole anti-state ideology, right? It's the idea that your judiciary is not good enough. And it's even like a differentiation in terms of money, right? So if you as a citizen go to Colombia and buy a house, and there's a problem because the land ownership is questioned or whatever, you're going to have to go to Colombian court to resolve your problem, right? But if you're Coca-Cola or if you're Chevron, then you do not get taken because you have big bucks, essentially. The only difference between a citizen and a corporation is, right? I mean, it's not the only difference, but one of the key differences is the amount of money you're bringing into the country, right? So if you have big money and you're a corporation, you will not be taken to court in a national jurisdiction. You will be taken to court in these corporate courts. So it's full of ideology. It's anti-state. It's all about weakening the sovereignty, and actually I would say the institution building, because it also weakens course, the judiciary of these countries by not recognizing their legitimacy, right? So it's anti-development in every possible way, not just in economic terms, but also in the building of a social contract, of strong institutions, and so on and so forth. And the ideology of neoliberalism now is being put to the test and questioned more and more, and which is why we're seeing some pushback against these corporate courts now, because it's the product, it's the part and parcel of an ideological moment, which is being increasingly questioned.
Yeah. I think it's telling as well. It's always with these trade campaigns, they seem so impossible to deal with when we start. So many people go, how on earth can we affect the international trade system? And yet they're actually the campaigns that we're most likely to win often, whether it's like the campaign against the Transatlantic Trade and Investment Partnership or the ECT and so on. It is actually very possible to win these, and I think it's going to be possible to convince the UK government to come to the table with Colombia as well. There's just one small question. I think this is going to be a really simple answer. Somebody's asked it in the chat. Would Equinor be able to sue the UK government if it doesn't give approval for Rosebank? Is the answer yes, Cleodie?
Which country is Equinor from? I should know.
Norway.
Not Equinor, but Suncor can, is that its name? Can sue using the Pacific Trade Deal, because Canada has access to ISDS.
Okay.
So it depends on the specific nation that is their host state and what treaty there exists. I'd have to look into it, but I do know that there is a risk with a Canadian company over North Sea oil and gas.
So this was exactly our argument in the campaign against the Energy Charter Treaty, but of course, getting rid of that doesn't get rid of all the threats. So this is why we need to bring the whole ISDS system down, which is what we're engaged in, partly as an organization. So I'm going to bring this webinar to a close now. Thank you so much for coming. If you're not already a member, please do consider joining Global Justice Now. We're completely people-powered. We take on corporations, we campaign for people before profit in the global economy, but we can't do it without the support of lots and lots of ordinary people giving small amounts each month. So please do consider joining. Thank you so much to all of our speakers, to Juan, Sebastian, Guillaume, Cleodie, and also thank you to our translators, Patricia and Alexandra. We look forward to hearing from you and about the campaigning you're going to be doing on this. Good night, everyone.
Thank you, everyone.
Thank you. Good night.